Hello, this is Craig Stone at Stone Law Offices, and I'm launching our very first 5 at 5 live Facebook feed regarding some things that we think the public should know about regarding estate planning and the frequently asked questions that come up throughout our consultations. So today I want to talk about the difference between a last will and a revocable living trust. Now, when people ask us that question, we usually say, listen, you can go down one of two paths doing your estate planning. The first one is a last will and testament, and that's what everybody presumes it to be. It's a piece of paper that says, when I pass away, I'm going to appoint person X to be my executor. I want them to settle up my final affairs and then distribute my assets to persons 1, 2, and 3, spouse, children, grandchildren, etc. The advantages to a will is that it's relatively quick and easy and pretty inexpensive to set up, though there are three primary downfalls to a trust. First of all, downfalls to a will. First of all, a will does not go into effect until you pass away. And that means that if you become disabled or incapacitated or incompetent prior to you passing away, the will is not going to address all those issues. And so you will likely have to have other documents to go with that, like a healthcare power of attorney and a financial power of attorney and those items. The second thing is a will does not take effect unless it goes through a process called probate. And what that is your will is submitted to a judge, and the judge looks at it and makes sure it was properly signed and witnessed and notarized, and then grants the authority to your executor to carry out your instructions. Prior to that going through probate, that will has no legal effect, and the executor has no authority to go out and settle up your affairs, close your bank accounts, or distribute your assets. The problem with probate is that it's very expensive, it is very time consuming, and you have complete loss of privacy regarding the affairs of your will and the items in your estate, because everything that is in the public record in the courthouse can be accessed to strangers, family members, people who you may not want to know about your particular affairs. Then the third thing about a will is, while it is relatively easy to set up, it's really not designed to address some of the unique things that you may want to take care of regarding your beneficiaries. If you've got minor children, if you've got heirs or beneficiaries that may have circumstances like substance abuse or impulse control, or you need to leave some parameters about when and how they are to have access or use the money, a will really isn't a good vehicle for doing that. So that's the first path you can go down. That's a last will. Quick and easy, but it's got some potholes that you have to navigate. Your other option is a revocable living trust. And a living trust is basically a contract between you and yourself, or you, yourself, and your spouse, if you're married. It says, this is how I want assets and things to be handled while I'm alive. This is how I want things to be handled if I become incapacitated. And this is how I want things to be handled when I pass away. Now, the distinct difference between a will and a trust is this. The trust takes effect immediately after you sign it. And so if you do become incapacitated, if you do have a disability or an incompetency, your trust is already in place and already has instructions about how things are going to be handled by your trustee, which is the same person that would serve as an executor. The second advantage of a trust is, to the extent that your trust is properly created and you take all of your assets and you fund them or retitle them in your trust, then when you pass away, your trust does not have to go through the probate process. It is exempt from having to go in front of a judge and have a judge grant authority to the trustee. And that means that your trustee can get down to doing the job that's intended, which is settling up your affairs and hopefully getting things distributed to your beneficiaries as promptly as possible. You save some of the administrative time and headache associated with the probate proceedings, but you also get privacy. Because the trust does not go through the probate process, it becomes less open to public scrutiny, and only the people who you choose to share it with would know about it. Now, A trust is much more comprehensive, and therefore it has a little bit more cost associated with setting it up. But in the long run, the cost of a trust is still significantly cheaper than the cost of a probate on the back end of a will. So there it is. That's the difference between a last will and a revocable living trust. This is our first 5 at 5 live. I hope you enjoyed it. Join us every Tuesday and Thursday at 5 p.m. Pacific for another installment where we'll be talking about new questions that come up with our clients. Thanks a lot. Have a good night.